Good morning. This is Eric Becker. I'm the head of the Labor and Employment Practice here at Cummins & White, and I'd like to first thank you all for attending this morning on this webinar on social media in the workplace and guidelines for employers. For those of you who have attended our webinars in the past, as you know, we encourage you to ask questions during the course of the webinar through the chat or questions dialog box on GoToMeeting. So I encourage you to do that. And of course, at the very end, if you have any questions as well, I'll be glad to answer them. A couple of other housekeeping things. If at the end of the presentation you would like a copy of the slides in PDF format, I will be glad to send them to you. Just go ahead and shoot me an email, and I will send those out later today. Also, we will be having webinars pretty much once a quarter this year. We will probably be having a webinar sometime in August, as well as towards the end of the year in the October, early November timeframe. So I encourage you to sign up for those webinars as well. It's a great way to get some good knowledge about what's going on in the area of labor and employment, and also ask questions. But of course, in between webinars, if you ever have questions about anything having to do with labor and employment, please feel free to either give me a phone call or send me an email. Okay, so we're going to get started with the presentation now. And I want to first talk a little bit about what we're going to be covering today in today's presentation. First of all, I want to quickly go over, when we talk about this concept of social media activities, exactly what is it we're talking about. This is a pretty hot topic. It seems like every week or couple of weeks we see decisions coming out in this area. And so I just want to start first with some of the basics before we delve into some of the laws and statutes and administrative decisions that are out there. Next topic we're going to be discussing is what are the parameters for employers to restrict social media activities on the part of their employees, both on company time and in using company equipment. So we're going to talk about, okay, what can you do to restrict people from engaging in these activities while they're working, while they're using your equipment, and then we'll talk a little bit about what are the limitations on employers. First of all, we've got some California laws that have been enacted that protect employees who engage in social media activity. And then we've also got a large body of law that is continuing to develop under the National Labor Relations Act, whereby the NLRB, the National Labor Relations Board, has stated multiple times that employees engaging in protected concerted activities using social media cannot be disciplined by their employer. And furthermore, that employers cannot have overbroad social media policies. So I'll get into all of that in terms of when you can and when you cannot discipline employees for engaging in social media, and how you need to structure your social media policies so that they are lawful and they're not found to be unfairly interfering with employees' rights. We're also going to talk a little bit about what employers' rights are in terms of monitoring the social media activities of their employees, both on the job and off the job. And finally, we'll talk a little bit about what disciplinary action can be taken when employees violate the lawful restrictions that you have in your social media policies, if you have one. And of course, if you don't have one currently, hopefully out of this webinar, you can get some tips and pointers for drafting a social media policy. Or, of course, if you ever need assistance on something like that, please feel free to give me a call. So that's what we're going to be covering today. Let's first start with just broadly defining social media activities. So we've got our cartoon over here where the, I guess the guy's climbing the mountain to go to the wise man to ask the deep philosophical question, if a tree falls in the forest but you don't hear about it on Facebook, MySpace, YouTube, or Twitter, did it really happen? And that seems where our society is going right now. with a lot of people spending a lot of time on social media sites. And of course, you've got your traditional social media sites, the Facebooks, the Twitters, the YouTubes, the LinkedIn, chat rooms, etc. But especially for the millennial generation, they are moving to more emerging social media applications, things like Instagram and Pinterest and Snapchat and Tumblr. And the only reason I know about those is because I have teenagers. I think for those of us who didn't grow up with the internet, we think of social media as, you know, the big three, you know, Facebook, Twitter, and YouTube. But really, these emerging social media sites, which can be accessed very easily by smartphone as opposed to by the traditional computer, are becoming much more dominant with younger folks. What are activities that are considered social media activities on these sites? Well, obviously posting, you know, entering something into the site, or viewing the site, or utilizing any internet-based program that can be shared with others. When you look at Tumblr, for instance, it's a lot of pictures and it's just sharing, and people oftentimes don't post on Tumblr, they just read it. So social media activities, as I mentioned, can be conducted on any electronic device that accesses the internet, and more we're seeing people access through smartphones or tablet computers rather than on a traditional desktop or laptop computer. So any electronic device that can be used to access the internet can be a source for social media and social media activities. So now that we've got our broad definitions down, let's talk about what employers can do to restrict social media activities by their employees. First of all, employers can have a blanket prohibition on engaging in these activities during working time. Working time is for work, and an employer can certainly have a policy or have a practice of restricting employees from going on their Facebook page, posting on Twitter, you know, reading Instagrams while they're supposed to be working. Now, important to recognize, and this is very similar to non-solicitation rules. Working time does not include breaks and lunch, meal periods, or before and after the employee's shift. So an employer cannot prohibit an employee from engaging in these activities while they're on break. If somebody wants to pull out their iPhone while they're in the break room and start posting on Facebook, the employer really cannot prohibit that from occurring. Now, the second big part of restrictions that employers can put on social media activities is you can prohibit employees from accessing social media using company-issued equipment. So if people have got laptops, iPads, smartphones that are issued by the company, you certainly can have a policy and a practice of prohibiting people from accessing social media sites using that company-issued equipment. There's a gray area, though. And the gray area is situations, and I've seen this very often, where an employee's got an iPhone or a Galaxy or any one of the other smartphones that are out there, that the employee bought it. And maybe even the employee has the account with Verizon or AT&T or whatever the case may be, but the charges, the monthly charges, are paid by the employer. Is that company-issued equipment? Well, I think an argument can be made both ways. I think you can make an argument that if the employer is paying for it, the employer has the right to control it. But on the other hand, if the phone's owed by the employee and the account's in their name, the fact that they're just getting reimbursed for it, I think the employee could have an argument too that you can't control what I do on my smartphone. So that's a real gray area, and if you ever run across that, I encourage you to give a call so we can discuss it. But for the most part, when we're talking about desktop, laptop, iPads, smartphones, anything that is owned by the company, that is issued to an employee, you can prohibit employees from accessing social media on that equipment. Now, We talked about you can prohibit activities during working time, but working time doesn't include those off-duty periods. There is an exception, and that is if an employee is engaging in social media activities during their non-work time, but their activities, their conduct, would violate company policies, then that can be restricted. And we'll talk about that in a little more detail when it comes to disciplinary action and in crafting a lawful social media policy. But the only time an employer can limit social media activities during off-duty time is when those activities would violate a legitimate and lawful company policy. And the biggest example is an employee goes on Facebook or goes on Twitter and starts posting things that violate your sexual harassment policy. Just because they're doing it on off-duty time doesn't give them a get-out-of-jail-free card. So we'll talk a little more detail about that later on, but that is the big exception. So now that we've talked about generally what employers can do to restrict social media activities, let's talk about the specific statutory and legal prohibitions on employers restricting social media activities. There's protections for employees that were encapsulated here in California in an Assembly Bill, AB 1844, that was passed a couple of years ago. And it's got a lot of media attention at the time, so a lot of you may be familiar with this, but let's just cover some of the basics of AB 1844. Number one, an employer cannot require applicants or employees, so either somebody applying for a job with you or somebody who works for your company, to divulge their passwords or their login info for their social media sites. And this, of course, arose because employers were requiring applicants to hand over their Facebook password so they could look at their protected areas in their Facebook accounts. And the legislature stepped in and said, no, 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 you can't require employees to do that unless there's certain exceptions which apply, which we'll talk about in a second. But generally speaking, you can't do that. And furthermore, AB 1844 says you can't require employees to access their Facebook account or their Twitter account in front of their supervisor or in front of their manager. In other words, you can't get around this restriction on forcing employees to divulge their passwords by saying, well, just log on in front of me and I want to see what's on your Facebook site. You can't do that. And finally, you can't force the employee to print out or do a screenshot, anything that would force them to divulge the content of their social media site. And of course, we're talking about private content because, as we'll discuss, if they've got public content and they're not protecting it, then it's fair game. But if they've got private, password-protected areas in their Facebook site or any other social media site, you can't force them to divulge what's on there, with some exceptions. So let's talk about the exceptions in AB 1844. An employer can require employees to give their password and login information or require the employee to access the social media site and show it to the employer where the information may be relevant to investigation of misconduct or violations of laws or regulations. If you get, for instance, information that an employee is engaged in theft, and the way you know or you hear about it is that they're bragging about it on Facebook, or they've set up an eBay account and they're selling company product on eBay, that is clearly misconduct, if it's true, or could be criminal. And in those circumstances, you can require the employee to hand it over because you're looking for evidence as part of your investigation. That's a very limited exception. We need to be clear on that. Misconduct is a higher level than just the employees doing something wrong. You got to be able to show that what they're doing is a pretty serious infraction of the employer's policies in order to force them to give you the password or force them to access the site in front of you. So I just want to make it clear, this is not carte blanche for employers. You've got to have some pretty good justifications for going forward and requiring it related to an investigation. And of course, the other exception in AB 1844 is that if you issued the device to the employee, you absolutely can require their password and their login information. For instance, if somebody gets an iPad from the company and they've put some sort of password on it, well, the companies are well within their rights to require the employee to hand over the password to that iPad because it's not the employee's iPad, it's the employer's. So that's another exception in AB 1844. But other than those two exceptions, you can't force the employees to give up private, protected areas of their Facebook, LinkedIn, Twitter, other accounts. So that's California's law. Let's talk about the federal law that has been developing under the National Labor Relations Act, and it's being developed by the NLRB, the National Labor Relations Board. And just to make sure everybody's familiar, this governs all private sector employers, union or non-union. So the rules that the NLRB has been developing in this area governing social media pretty much applies to all employers, inside California, outside California, etc. And what the NLRB has ruled ever since really the advent of social media, so this goes back 6, 7 years when social media really became prevalent, is that employees have rights to use social media for certain purposes. And what the NLRB says is protected purposes is what's called concerted activities. So concerted activities are defined as discussing or protesting or doing something related to the terms and conditions of employment. When we're talking about terms and conditions of employment, we're talking about wages and benefits and other things the employer does, discipline, scheduling, anything that really is related to how the employee is treated by the employer is a term and condition of employment. So a concerted activity is where 2 or more employees are involved, okay, or you've got one employee who is acting on the behalf of others or discusses with others before acting. And let me just spend a little bit of time explaining what this means. In order for, under the Act, under the National Labor Relations Act, in order for employees to be engaged in concerted activities, they've got to be doing it in concert with others. In other words, what the NLRB has said is, look, if it's just one employee who's acting in their own interest and they're not involving others, they're not doing anything for the benefit of others, they're just doing it for themselves, that's not concerted and therefore it's not protected. But if there's 2 or more employees who are involved in discussing or protesting a term and condition of employment, or the employee can show, hey, I'm doing this on behalf of others, or I talked about it with others before I posted on Facebook, and they were all on board with what I was doing. Now you've got the element of concerted action. Employees joining together to do something to protest or discuss their terms and conditions of employment. So in order to be protected, it's got to be something having to do with terms and conditions, and it's got to be concerted. So what the NLRB says is that if you're on social media and you're engaged in protected concerted activities, you can't be disciplined or terminated for that. However, there are certain activities that are going to be unprotected, whether they're on social media or not. Unprotected activities include personal gripes that don't impact others. I don't like my supervisor. He or she is really mean, and I hate coming to work, and I hate dealing with them, and it's a me thing, right? That's a personal gripe. You post that on Facebook, that is not protected concerted activity. What else is unprotected? Spreading false information that harms the company's business or defames their products or services. Let's say somebody, for example, goes on Yelp, and they start making posts on Yelp about their employer, which happens to be a restaurant, and talking about how the employer's got rats in the kitchen, and they spit in the food, and all these horrible things. Well, that's not protected activity, because you're going well beyond your rights and spreading false information if those things are false. Now, if you're reporting it to the county health department, of course, that and the county health department comes in and says, yep, you got rats in the kitchen and you're spitting in the food, well, that's protected whistleblowing, right? But if you're spreading false information or you're trying to defame the company's products or services, that's not going to be protected. Same thing with threats of violence. You can't go on Facebook or Twitter and start posting threats about beating up a supervisor or going to bring a weapon to the office or anything like that. That's going to be unprotected, as well as harassment. Now, remember, we're talking about unlawful harassment here. There's a couple cases, which I'm going to talk about in a second, where employees have gone on a social media site and they have said disparaging things about their supervisor or about coworkers. And if those disparaging comments don't qualify as unlawful harassment, okay, meaning they're based on race, sex, religion, all the protected classifications, right? If it's just somebody being rude or saying rude things, and it's not unlawful harassment, it may be generalized harassment, but it still may be protected. What's not protected is when you engage in sexual harassment or racial harassment or national origin harassment using social media sites. Of course, also, publishing trade secret information of the company is not going to be protected, right? You can't go online and start posting all of your price lists for the company or blueprints or designs or anything that would be a trade secret. That's going to be unprotected as well. So we've talked about what's protected concerted activities. We've talked about what is unprotected. So using this generalized framework, the NLRB has found companies have engaged in unlawful restrictions on the right to engage in social media activities in two broad categories. One is taking disciplinary action or terminating employees who have engaged in protected concerted activity on social media sites. And secondly, the NLRB has found employers have violated the law by having overbroad social media policies, policies that, in essence, give a message to employees that they can't engage in protected concerted activities on social media. So I'm going to give you some examples of each of these so we can understand where the lines are in terms of the NLRB, what's going to be unlawful and what's going to be lawful in terms of disciplinary action and in terms of social media policies. Let's start by talking about where the NLRB has found that employers have unlawfully terminated employees for engaging in protected concerted activities on social media. First of all, there was a case where a number of employees posted negative comments about a coworker who was critical of their job performance on Facebook. So let me talk about this case. So this was a case where it was a number of employees, roughly about 5, who had kind of heard through the grapevine that one of their coworkers was telling their supervisor, they all had the same supervisor, that they weren't doing their jobs correctly. And these employees, one of them in particular, went on Facebook and posted something critical of this coworker. Basically, she's ratting us out, and she doesn't know what the heck she's doing, and how could she be critical of us, and et cetera, et cetera. And then, of course, other employees who were her Facebook friends started joining in and posting critical comments about this coworker. And the employer found out about it and terminated all 5 employees. Said, hey, you can't go on social media and start criticizing a coworker. That's like harassment. The NLRB said, wait, this whole topic touches on a term and condition of employment. These employees were concerned that they were going to get in trouble and maybe be disciplined over their performance, which they believed the employee was falsely giving the manager information about their performance, and therefore they banded together to protest what this coworker was doing. So it touched on a term and condition of employment, and it was concerted because they all got together in the social media world to complain about this coworker. And the NLRB said, yeah, that's protected, and they overturned those terminations. Another case that the NLRB decided recently was a number of employees went on Facebook and complained about their supervisor. Their supervisor wasn't treating them fairly. Their supervisor wasn't a good supervisor. Really kind of disparaging that supervisor. And again, the NLRB said, look, you've got employees who are joining together using this social media outlet to complain about their supervisor. That's a term and condition of employment. That's protected. And employer, it was unlawful for you to terminate those employees. Another case that came up, this goes back, this is one of the first cases the NLRB decided. A number of employees started posting on YouTube complaining about safety concerns and actually showing certain things at the work site that they thought was unsafe. And the employer found out about the YouTube postings and terminated all of them. And the NLRB said, no, it's absolutely protected. They were using YouTube to protest a term and condition of employment, and employer, that was unlawful to terminate those employees. This last one was very interesting. This was an employee who went into an online newspaper comment section. Some of you may have seen this. The LA Times or the Orange County Register posts an article, and below the article, readers can comment. And in this circumstance, there were articles about this employee's company, and the employee went into the comment section on those articles and started posting negative things about the employer's management. And the NLRB struggled with this a little bit because it wasn't clear-cut that this was concerted activity because it was just one employee. But what the NLRB found was, look, the employee had discussed it with other employees who had the same complaints or concerns about management, and therefore, even though he was acting alone in posting in this comment section of the newspaper, it was still concerted because he was doing it on behalf of other employees, and therefore it was protected, and the employer unlawfully terminated him for posting these negative comments about management in the newspaper. So those are some examples of where the NLRB has found discipline or termination unlawful. Let's talk about cases where the NLRB has found that termination or discipline was proper because the employee's activities were unprotected. NLRB decided a case a couple of years ago where an employee went on Facebook and was just venting about a conflict he was having with his supervisor. And it was an individualized conflict. He didn't involve other employees. He didn't discuss it with other employees. He was just, and you see down here our Twitter example, I hate work with a passion more than anything in the world, almost quit and punched my boss today. It was very focused on this individual's gripes with his supervisor. And by the way, that Twitter post is just an example. That wasn't the actual Twitter post from this case. But in this case, the NLRB said, look, this was solo activity. This wasn't concerted. Even though it was something having to do with terms and conditions of employment, we're going to find this as unprotected, and therefore the employer did not unlawfully terminate the employee. Another case came out fairly recently. These were employees at a youth center, so they were like counselors at a youth center, and they went on Facebook and they started posting F-bomb-laced diatribes against the company. And it was interesting because the NLRB has found in the past that using expletives can be a form of protected concerted activity. Just because you're using expletives doesn't mean it's automatically unprotected. But these guys were counselors at a youth center. And this youth center, trying to work with kids, had a reputation in the community to uphold. Clearly, these counselors were supposed to be mentors and somewhat role models for these kids. And when the NLRB looked at it as a whole, they said, look, in this circumstance, these types of postings were significant violations of company policy, and in these circumstances, we're going to find this as unprotected. So I mention that because just because an employee goes on Facebook or Twitter or any other social media site and uses an F-bomb or any other expletive doesn't automatically mean it's unprotected. But in certain circumstances, it can be. There was another case where the NLRB employee had been terminated for posting pictures of an accident at the work site and had made denigrating comments about the people involved in the accident with his posting. And the NLRB said, look, that's over the line. You know, you can't, there's no concerted purpose for this. It's not anything touching on terms and conditions of employment, and therefore that was unprotected and the employee could be terminated for doing that. We also had an NLRB case where an employee complained about a coworker and a supervisor on Facebook, but similar to the one at the top of this page, there was no back and forth with any other Facebook friends who were employees. In other words, none of the employees' other friends posted anything in reply, commented on it, didn't hit the like button. There was nothing to show that there was anything done in concert. And the NLRB said, look, this is just like those situations where somebody goes on and vents about their own personal conflicts with other people. That's not protected because it doesn't touch upon terms and conditions, and it's not concerted. So that's kind of an overview of what the NLRB has found when it comes to disciplinary action. Let's talk about social media policies for a couple minutes. The NLRB has found that social media policies are unlawfully overbroad when, for instance, the policy prohibits posting of confidential information without any definitions. And I've seen this in a number of social media policies where the policy just says employees are prohibited from posting any confidential information about the company. Without any definition of confidential, employees could construe that to mean, for instance, they couldn't post anything about their wages and benefits. And posting about wages and benefits can be protected concerted activity. If an employee wants to go on Facebook and complain that they're underpaid because they're only making $13 an hour, that's for the most part going to be protected. So what the NLRB says is, look, if you just have this broad definition of confidential without anything specific saying what would be confidential and what wouldn't be, we're going to find that's overbroad. So we'll talk about, in a couple of minutes, how you can craft your social media policy to make sure that you're clear in defining what would be confidential and forbidden from being posted on social media. Next, the NLRB has found that in the context of social media policies, or actually other policies, that if the company forbids rude, offensive, demeaning, or abusive comments or activities that would, quote unquote, damage the company, that's too general. Because what the NLRB says is, look, if an employee wants to go on Facebook and post something denigrating their supervisor and doing it in concert with other people, it may be rude, but it's still protected. So having a broad policy that prohibits anything that is rude or offensive, because, of course, people can be offended very easily, that is going to be unlawful. That's overbroad. It can restrict employees from engaging in protected concerted activities. Same thing with activities that would, quote unquote, damage the company. That's too generalized. If it said something along the lines of postings that would damage the company's reputation in the community, that may be starting to get more specific. Even better would be something that says postings that directly would damage our product or services. Now you're getting specific enough where the NLRB says, okay, that's not overbroad. Another overbroad policy that you oftentimes see is requiring prior approval from the employer before posting anything. That, the NLRB says, is a form of censorship. You can't require the employer to approve before posting. That would restrict employees from engaging in protected activities, and therefore it's unlawful. Same thing here, a general restriction about an employee posting photos, video, or comments about the company. That's too overbroad, because somebody could, like we talked about in one of those previous cases, take video on their cell phone of safety concerns and post that on YouTube. That would be protected. So a broad policy prohibiting that is going to be unlawful. Another common overbroad provision you see in social media policies is requiring posts to be accurate and not misleading. Again, too generalized. The NLRB says that would chill employees from engaging in, for example, protesting their wages, because they could think, hey, you know, if I put something up there and the employer says, oh, that's misleading, we're going to discipline you, I don't want to get in trouble. And so that is an overbroad policy. Lastly, prohibiting the use of company, your name, your trademark on social media sites. I'll give you an example. There's been a lot of social media surrounding the recent fast food strikes, the Fight for 15 movement, which is the movement of fast food workers trying to get the $15 minimum wage. And when you look on all of the social media sites promoting this, whether it's Twitter or Facebook, they commonly use the McDonald's logo. Okay? And the NLRB has said, look, when you're using the logo as part of your protest, same thing with Walmart. Lot of social media protests regarding Walmart, and you know the Walmart smiley face. Well, they love to misuse that, you know, make it into a frowny face, etc., to protest Walmart's policies, and that's protected. That's protected activity. So a social media policy that prohibits the use of company names or trademarks is going to restrict unlawfully employees' ability to engage in those types of activities. So let's talk about lawful social media policies. What can you put in your social media policy that's not going to run afoul of these restrictions that the NLRB has put on? First of all, what you need to do is focus, first and foremost, on prohibiting activities during work time or using company equipment. You have to be very clear about that in your policy. If You're using work time to engage in social media, whether that's protected or unprotected, by the way. Okay? If you're doing it on work time, it's unprotected. You can't use work time for non-work related conduct. So your social media policy should prohibit activities during work time, carving out lunch breaks before and after work, and it should certainly state that any company electronic equipment, so you want to be really broad here. You don't just want to talk about computers, right? We're talking laptops, iPads, iPhones, or other smartphones. Any type of electronic device that has the capability of connecting to the internet, you can't use that equipment to engage in social media activities. Next, you want to have specific definitions or examples of prohibited conduct. Okay? This is where you want to get down to the nitty-gritty. What's the type of social media activity that is going to be prohibited? Well, first of all, you want to define what is not considered confidential or trade secrets, right? So you should have a confidentiality policy in your handbook, and you can refer back to that in your social media policy. But your confidentiality policy should specifically say, okay, this is what our trade secrets would constitute, right? Things like financial information about the company, our designs, our inventions, our customer lists, customer information, et cetera, et cetera, et cetera. What's not confidential? Okay? Information about the wages and the benefits and the other terms and conditions of employment of that employee. That's not confidential, so that the signal can be given that, hey, if you want to post about that on social media, that's not going to be a violation. You also want to talk about what, it's rather than saying we prohibit offensive postings on social media sites, you want to be very specific about what would be considered offensive. Okay? Posting things that would violate our policy against harassment. Posting things that have a racial, sexual component that is demeaning to others based on race or sex, right? You want to be very specific about what constitutes offensive conduct. And of course, refer to other company policies. And a good social media policy is always going to refer back to your harassment policy, your confidentiality policy, your policies against conflicts of interest, which should be really complete. And therefore, if you're just referring back to those, you're giving employees very specific guidelines that they have to follow rather than general guidelines that can be overbroad. You also want to make sure in your social media policy, and I've seen this in a number of policies, that you avoid something generalized saying if employees engage in unauthorized social media activities, it will lead to discipline up to and including termination. The generalized threat of discipline in connection with social media policies is frowned upon by the NLRB. I don't think you need to have language in there that necessarily says violation of our social media policy will lead to disciplinary action, because most of the time when people are violating a social media policy, what they're really doing is violating another policy of the employer, whether that's your confidentiality policy, your policy against conflicts of interest, etc. So it's not. So can you go back here? So it's not really necessary. Last thing you want to do is you want to make sure in your social media policy that you advise employees in great detail about monitoring. What I mean by that is their electronic devices that are issued by the company, whether that's their iPhones, their iPads, their computers. The employer is going to monitor them, and there should be no expectation of privacy, which we'll talk about in a second. It's also a good idea to make sure that you're advising employees that their public social media sites, in other words, people post on Twitter, people post on Facebook, and they don't shield it. It's just out there for the public. That may be monitored as well. Go ahead. So you can always monitor employee activities while they're online using company-issued equipment. Pursuant to your policy, notifying the employees that they have no expectation of privacy if they're using the company computer to go on the internet or they're accessing the internet through their smartphone issued by the company. And, as I just mentioned, you can monitor activities in public postings. Give you an example. If someone posts on their Facebook page, on their public Facebook page that is accessible to everybody, that they're traveling for vacation. They're in Hawaii. But they've told their employer that they have to have 2 weeks off under FMLA for surgery. Okay? And the employer suspects that maybe there's something fishy about this, and they just happen to look at that employee's Facebook page and see they've got pictures snorkeling at Hanama Bay in Oahu. That's going to be a legitimate basis for taking disciplinary action, because the employer certainly is entitled to monitor those public postings and to use that information. The employee was not smart enough to protect that, or maybe just refrained from posting on Facebook at all, and too bad, so sad. Now, if an employee voluntarily friends a supervisor or manager, in other words, the manager doesn't say, hey, I require you to make me a friend on Facebook, but the employee, for whatever reason, voluntarily sends a friend message and friends the supervisor or manager, giving them access to certain portions of their Facebook site, then again, it is not a problem if that manager or supervisor discovers something on that Facebook site that could be used against the employee. It's not protected concerted activity, right? Something like I just described, the employees posting vacation pictures when they're supposed to be in surgery. That is on the employee. They made the mistake of friending that supervisor or manager. Now, as a general rule, I would not advise supervisors or managers to go out and seek to friend employees. I think that's not a good practice. Frankly, a lot of the stuff that goes on Facebook you really probably don't want to know about. But if an employee voluntarily friends the supervisor or manager, again, I'm not a fan of supervisors or managers accepting those friend requests, because you want to have that separation between managers and supervisors and the people they supervise, and it kind of blurs those lines when all of a sudden, you know, you're posting all weekend about all the things you're doing off work. But if it does happen and the supervisor or manager sees something on that Facebook page that would be a violation of company policy, they can certainly use that information and pass it on to HR or whoever. So finally, let's talk about disciplinary action. Remember, we talked about protected concerted activities. If people are engaging in protected activities on social media sites, you cannot discipline them for that. Even if it's a lower level discipline, written warning, verbal warning, the NLRB says it is not lawful to discipline people for engaging in protected activity on social media. You can, however, discipline people if they violate company policies. This is what I was talking about earlier. If you can't rely on harassment as a catch-all for activities on social media sites that you don't like. Okay? You can't, if somebody's saying negative things about their supervisor, you say, well, the supervisor is being harassed. Well, if it doesn't have a racial, sexual, national origin, religion component, one of those protected things, then it's not unlawful harassment. It's not a violation of your policy, and as a matter of fact, it's protected. But on the other hand, if you've got an employee who is harassing another employee about wanting to go out with them, or posting pictures of them that are salacious, things like that, that would violate your harassment policy if they were going on in the workplace. Even if they're going on outside the workplace on social media, that still is a violation of your harassment policy, and you can take action against that. You can certainly discipline if social media activities reveal that the employee was dishonest. Like we talked about, faking the surgery in order to go on vacation, if social media shows that they're engaging in theft, or that they lied about something that's related to work, then you can take action for that. Because you're not disciplining or you're terminating them for their social media activities. You're doing it because they're violating your policy. Now, we have to make sure we understand that off-duty conduct that is chronicled on social media, which is unrelated to work, cannot be a source of disciplinary action. Because even in California, there's certain statutes that protect employees from engaging in off-duty conduct that is unrelated to work. So, give you the example. I'm sorry, go back, Jenna. The example is you've got an employee who is posting on Facebook, on their public site, and they're posting about how every weekend they're going out and getting hammered, drunk. And there's pictures of them doing tequila shots. And okay, well, as long as they're showing up at work and their performance isn't being impinged, you can't take action against them because they're engaging in off-duty conduct that isn't a violation of company policies. They're doing it off-duty, okay? And that would not be a legitimate basis for taking action against someone. But what about this scenario? Let's say an employee is posting on Facebook and there's pictures of them doing drugs, doing illegal drugs. Well, if you've got a drug testing policy and you've got a policy against employees using illegal drugs, and you see on Facebook that, they got a big bong in front of them, and it's kind of like that Miley Cyrus situation, right? Should you take action against them just because of that picture on Facebook? My advice would be no. Can you drug test them? I think that would be reasonable suspicion. If you have a reasonable suspicion policy in your handbook that allows you to test people based on reasonable suspicion that they might be under the influence, that would be a basis for drug testing them. So there is certain off-duty conduct that would be a violation of your policy, right, that you can take action for if you notice it on Facebook. But if it's just another example, you determine through social media posting somehow, whether it's Twitter or you hear some information and you see something on Instagram that an employee is engaging in an affair. But it's not an affair with another employee. It's completely outside of work, nothing to do with work. Can't take action based on that. That's not a lawful basis for disciplining an employee. Okay, so we're just about at our hour. I want to ask if anybody's got any questions. Trying to pull up the so it looks to me like we've got a question here. So we're talking about social media. Would social media policies be able to be extended to someone accepting an important phone call? Or is that a separate phone policy? I think what this is referring to is, and correct me if I'm wrong, you can post again, off-duty conduct. And if that's the case, then I think what we're talking about is a separate phone policy rather than a social media policy, because we're talking about phone calls, not internet access. So we got another question here. Their social media activity is showing that they aren't in surgery. Is that even if it is on their private devices because they haven't set their privacy settings? Right? So here's the deal. And so we're talking about here is the issue with somebody who you see on Facebook is not in surgery, even though they've told you that they are, and for some reason they haven't set their privacy options and they haven't protected that. That's on the employee. That would be on the employee. If the employee failed to set their privacy options and it's public domain, then by all means it's fair game, and if the employer, through monitoring or other means, sees that the employee has been dishonest, you can take action against that. Oh, okay. We were talking about the blanket policy on smartphone use during the workplace. Okay, so we're talking about, yeah, it should be a separate phone policy. If we're talking about employees having their own personal smartphones or even employer-issued smartphones, and they're always interrupting work to take quote-unquote important personal phone calls, then by all means you should have a separate phone policy that talks about any personal phone call use should be limited to breaks, lunch, and before and after work. Because if people keep taking phone calls during work, that could be grounds for disciplinary action. Another question. If an employee has a medical marijuana card and posts drug references on a public social media site, is this protected? Great question. Medical marijuana cards, and I use this term again, they are not get-out-of-jail-free cards. Okay? Just because an employee has a medical marijuana card does not give them the right to smoke marijuana or be under the influence of marijuana while working. Okay? If you have a drug policy that says that employees are supposed to be free from taking illegal drugs, marijuana is still illegal. Okay? Still legal under federal law. And nothing in California statutes prohibits an employer from restricting employees from using marijuana. Okay? So, if an employee is on a public social media site and they're bragging about getting high every weekend, and there's pictures of them with their medical marijuana card and a big joint, right? That's not protected. Okay? And my advice again would be not that you discipline them for what you saw on the social media site. My advice would be you drug test them. Okay? Because if they pop positive, the disciplinary action is because they failed the drug test, not because they have a medical marijuana card. Because the fact they have a medical marijuana card or the fact that you see what looks to be a joint being smoked on social media isn't proof that they're doing drugs. Failing a drug test is proof they're doing drugs, and that could be a basis for taking disciplinary action. Okay, it looks like that's all the questions. Certainly, if you have questions afterwards, anything on this topic or anything else, there's my contact information. We have blog as well as Twitter, so feel free to subscribe to those. And again, if you want a copy of the PDF of these slides, please shoot me an email. I'll be glad to send it to you. I really appreciate all of you attending today. Thank you very much, and hopefully we will see you at the next, or I guess kind of digitally see you at the next webinar. We will be sending out notices for that sometime in July. Thank you very much. Have a great day.